16-265, State versus William Lewis. Drug paraphernalia, controlled substances, firearms by certain persons. Sir, I've appointed the Public Defender's Office to represent you. And let's see, looks like he's appearing for an arraignment.
That's correct, Your Honor, and we'll waive reading of the information and a plea of not guilty.
Okay, we'll enter that plea. He'll return on November 17th for a pretrial.
And Judge, I've spoken with the prosecutor. We're going to try to get that resolved well before that date, so we'll get in before you or Judge Webb, hopefully within the next few weeks.
Very well.
Thank you, Your Honor.
Saralyn, possession of paraphernalia, controlled substance with purpose to deliver, firearms with certain persons, weapon possession during a controlled substance offense. Is that a new statute? Relatively new?
I've never seen it before.
Seems like that would be encompassed by the simultaneous possession statute.
Would seem to.
Judge, Ms. Lynn appears here today. I think that we have been appointed now in both her revocation and her, actually, oh, I need to approach, Your Honor. I have a new application.
Okay.
In the new case.
I'm appointed Public Defender's Office to represent you. It looks like an arraignment in 16-263.
That's correct, Your Honor. We'll waive reading of the information and her plea of not guilty. She has a couple of issues, so we'd like to be heard on bond.
Okay.
May I proceed?
Yes.
Last time she was before you on during a video appearance, I think Mr. Wilbur was here and had withdrawn as her counsel at that time on the revocation proceeding. There was some disagreement as to whether or not she was told whether or not she had to leave or stay for the hearing that day. It's my understanding, in speaking to her, that she did, for the revocation at one point in time, post a $2,000 cash bond, and that's how she was out on bond at that point in time. We would ask at this time that the court allow that bond to stand good for that charge. We understand that there will be a new bond on the new charge, and I think that what it's set at now is probably something that we can live with. To reassure her appearance before this court. I think that right now there's a hold because of that FTA as well. So.
And yeah, I can.
Right.
Yeah.
Your Honor, the state would object to any bond. This revocation hearing for this lady is set for September the 1st. That's the last time she's sat in front of. We've been down this road before in terms of bond. This lady pled true to a revocation in February of this year. She's been an active person that has not been. She was supposed to be going into a rehab in February, and the purpose of her revocation, Your Honor, was one of the principal things of her revocation was her contact with a man named William Lewis, and she was arrested on this new charge with William Lewis, actively hiding in her home. Your Honor, we just want a revocation hearing so we can revoke this lady's probation. She's not going to go to rehab, so all we're left with is the revocation hearing that's set on September the 1st.
Is it before Judge Webb?
It is.
Well, given it's just a week, I'm going to leave things where they are.
Okay, Your Honor. I will talk with her. Thank you.
Okay. 16-262, State versus Thomas Hudson, aggravated assault. Sir, I've appointed the Public Defender's Office to represent you, and you're here for an arraignment, it appears. How does he plead?
Judge, he pleads not guilty. At this point in time, we would like to request that the bond be reduced to $1,500. Mr. Hudson has no prior felony convictions. Based on the allegations, I think that that's an appropriate bond, considering he will also be living with his family, his parents, when he's out.
I'd like to look at this gentleman's criminal history. I don't think that's an accurate statement. We passed it.
We'll call it later.
I've got several cases.
We'll take up your case later, sir. 16-203, State versus Tessie Churchman, furnishing prohibited articles. And I've appointed the Public Defender's Office to represent you.
I believe she's already been arraigned in this matter, Your Honor. I do have a plea offer here.
I haven't. This is my first appearance.
Okay. It says reappearance on the docket, that's why I assume that.
Yeah.
But we'll waive reading of the information and her plea of not guilty.
We'll enter that plea of not guilty, and if we haven't already done so, schedule the matter out.
Thank you, Your Honor.
16-127, State versus Caitlin Bridgers. Possession of hydrocodone, marijuana. This is 16-127. Sir, I'm looking at a police statement. Have you gone over this document?
Yes, sir.
Did you sign it?
I did.
Okay. You understand the charge against you and the range of penalties if you're convicted?
Yes, sir.
Are you pleading no contest to possession of hydrocodone and no contest to possession of marijuana?
Actually, the hydrocodone's being dismissed, Judge, and it's just no contest to the marijuana charge.
Okay, is that right?
Yes, sir.
Pleading guilty to, or not, no contest, rather to possession of marijuana.
Correct.
By doing so, you're giving up your right to a trial and an appeal. Do you understand this?
I do.
Okay. And are you entering the plea freely and voluntarily?
Yes, sir.
Okay, at this time, sir, I accept your plea of no contest and adjudge you guilty. You order to pay $200 in cost, a $500 fine, $20 booking fee, $200 in public defender fees, and you're sentenced to 30 days in the county jail. I guess you'd be given credit for time served. Have you served 30 days?
Yes, sir.